Welcome to Kilpatrick Townsend's Government Enforcement and Investigations Team's first podcast. We're excited that you've joined us. Today's podcast focuses on the effects of the Supreme Court's decision in Liu v. SEC, particularly when it comes to FCPA and bribery and corruption matters. My name is Andrea Perez, and I am a partner on Kilpatrick Townsend's Government Enforcement and Investigations Team. My practice focuses on representing corporations in white-collar criminal defense matters and government enforcement issues. I have conducted FCPA, bribery, and corruption internal investigations around the world, including in Europe, China, Mexico, Brazil, Argentina, Chile, Dominican Republic, and other locations. I was also part of a team that convinced both the SEC and DOJ to provide a declination in an FCPA multinational investigation. My colleague, Jessica Nwokocha, who is joining me on this podcast, and I were both part of the Volkswagen AG Independent Compliance Monitor and Auditor team, where we oversaw VW's compliance with a plea agreement and consent decree following parallel criminal and civil investigations concerning emissions fraud. It was an incredible experience, and we really got to know an incredible company of that size and importance in such a deep way. Jessica, what would you like to highlight from your own professional background and experience?
Thanks, Adria. I'm Jessica Wong. I'm an associate on the GEI team, as Adria mentioned. My practice focuses on representing corporations and individuals also in white-collar criminal defense matters, including internal investigations and government enforcement matters. I've done internal investigations in China and Russia, and like Adria, was a part of the VW Monitor team. And I also represent clients in compliance-related matters in various industries and have advised clients on all sorts of topics from face masks to FCPA matters.
Perfect. Well, Jessica, can you give us a high-level background on the Liu case?
Sure, let's get into the background about the case. And we will make sure that we drop the case citation in the description box below if you'd like more detail about the case. So you may already be familiar that in June, the Supreme Court ruled 8-1 in Liu versus SEC, affirming the Securities and Exchange Commission can continue pursuing disgorgement awards, but capping the award amount at the defendant's net profits and requiring that disgorgement be made for the benefit of wronged investors. So what happened in Liu? Charles Liu and his wife, Lisa Wang, solicited almost $27 million from foreign investors under the Federal Immigrant Investor Program, also known as the EB-5 program. Liu sent a private offering memo to investors promising that a bulk of investor contributions would go towards costs for a cancer treatment center, and that only amounts from minor administrative fees would fund legal accounting and administrative expenses. However, Liu ended up spending nearly $20 million of investor money on marketing expenses and salaries, which was more than what the offering memo allowed and far above the administrative fees that were collected. The SEC then brought a civil action against Liu and Wang, alleging that they misappropriated millions of dollars in violation of the Securities Act of 1933. The district court found for the SEC, they granted an injunction and imposed a civil penalty of $8.6 million, the highest tier authorized. Liu and Wang were then held jointly and severally liable for the full monetary amount. The district court also ordered disgorgement in the amount of $26.7 million, which was equal to the full amount the pair had raised from investors. Liu and Wang objected to the award. They said that the disgorgement award failed to deduct their reasonable business expenses, that the award was not returned to victims, and that the joint and several liability was imposed improperly. The Ninth Circuit affirmed the district court ruling, and then the Supreme Court granted cert. So then the question presented to the Supreme Court was whether, for securities violations, the SEC can seek and obtain disgorgement from a federal court as equitable relief, which is under the applicable provision of the Securities and Exchange Act. In deciding the case, the Supreme Court imposed 3 new limitations on disgorgement awards. One, that disgorgement remedies must benefit investors and be returned to victims. as opposed to being deposited into the U.S. Treasury. 2, that joint and several liability may not be appropriate in every securities case. And 3, that disgorgement awards cannot exceed a defendant's net profit, and legitimate business expenses must be deducted. Otherwise, the disgorgement award becomes more of a penalty instead of equitable relief. And then in dicta, the majority raised and discussed 3 questions that the lower courts should consider when assessing the disgorgement award on remand. 1, that the relief is appropriate or necessary for the benefit of investors, so whether that relief is really needed for the benefit of wronged investors. 2, whether there is individual liability for the wrongful profit. And 3, whether legitimate expenses are deducted. And so these questions will operate as guidance for lower courts to consider when deciding if an SEC disgorgement award is equitable. So even though the Liu case involves securities violations, Adria, can you tell us how the Supreme Court's decision in Liu relates to the FCPA as well?
Right. So obviously the SEC uses disgorgement as an enforcement tool. And just in fiscal year 2019, the SEC obtained over $3 billion in the disgorgement of ill-gotten gains. And so when it comes to the FCPA enforcement context, both the DOJ and the SEC have been able to obtain increased amounts of disgorgement over time. There was a big jump from fiscal year 2017 when it was $15 million to fiscal year 2018 when it jumped up to $45 million in disgorgement. So even in fiscal year 2019, it was around the same high amount at $37 million, which is still much higher than the fiscal year 2017 amount. We've seen over time how the SEC uses disgorgement as a way to resolve matters. Just in fiscal year 2019, the SEC obtained over $3 billion in disgorgement. And then in the FCPA context, both the DOJ and SEC have increased the disgorgement amounts they were able to obtain. From fiscal year 2017 to 18, it jumped from $15 million to $45 million. And even in fiscal year 2019, the combined disgorgement amounts for the DOJ and SEC for FCPA-related matters was over $37 million. I mean, prior to Liu, like Jessica expressed, disgorgement included just the return of the benefits or the proceeds from the corrupt scheme. But given the Supreme Court's decision in Liu, there's more to consider when determining disgorgement. And so these considerations can be advantageous when you're negotiating with the SEC to resolve FCPA issues, despite whether the SEC files a federal action against the company or relies on the specific equitable relief statute in which the Liu decision focuses on, especially those points regarding identifying legitimate business costs and victims. So Jessica, why is it important for companies to take into account the legitimate business costs and victims aspect?
So both the wrong victims and legitimate business expenses aspects of this case are very important for companies to keep in mind. For victims, it's important to note that in Liu, the funds that the district court ordered to be disgorged had not yet been collected. So at the time, it was unclear whether that money would be deposited into the Treasury or distributed to the investors after collection. So the Supreme Court did not analyze whether the disgorgement order improperly failed to compensate victims. As the court acknowledged, however, it might not even be possible or might be infeasible, as the court described, to distribute funds to wronged investors. So although the court didn't give any guidance on how lower courts should consider this practice of the SEC depositing funds into the U.S. Treasury, the court did mention that the method that the SEC's current solution to the feasibility issue, which is depositing the funds into the Treasury, is one of the SEC's methods that sort of tests the bounds of equity practice. So the court found that given the equitable nature of disgorgement, the SEC was generally required to return a defendant's gains to wrong investors for their benefit. So that's how the court got there. But up until Liu, there wasn't a victim identification requirement, and depositing all of the disgorgement funds into the U.S. Treasury has been assumed proper. And this is very significant because in FCPA cases, It's a routine practice that not just some, but pretty much all of the disgorged funds are placed in the U.S. Treasury. For example, of the 18 FCPA cases listed in the SEC's 2019 annual report, disgorgement was awarded in 13 cases. And where disgorgement was ordered, in all except for one case, the defendant was ordered to deposit all of the disgorged funds into the U.S. Treasury. And even in the 5 cases where disgorgement was not ordered, the civil penalty amount was also directed to be deposited into the U.S. Treasury. So while the court didn't address whether the SEC's policy of placing disgorgement funds into the Treasury instead of turning those funds over to specific identifiable investors could continue, the court just held open the question of whether disgorged funds could be deposited into the Treasury when the SEC is unable to distribute the funds to wrong investors. So ultimately, Adria, post-Liu, it seems like the SEC will have more of an incentive to seek lower disgorgement awards if victims are identifiable, because they would then need to return those funds to the victims instead of depositing the funds into the Treasury. But the onus is going to be on the lower courts now to determine whether disgorgement proceeds are being awarded for the benefit of victims. And they'll have to deal with what the open question is, which is whether it's ever appropriate for disgorgement proceeds to be deposited into the Treasury if disbursement to victims is not feasible. I think also notable here is that the SEC has used disgorgement money to fund some whistleblower awards. So this could mean a gradual reduction in the amount of funds available in the Treasury. But to limit liability, companies who find themselves in violation of the FCPA should really make sure to identify and list specific investors harmed by its conduct and challenge any disgorgement amount the SEC requests that is not specifically tied to those investors. As the Liu case shows us, depending on how much weight courts place on the argument that it's infeasible to identify victims and return those disgorged funds in FCPA cases, identifying specific investors could really become a crucial component of FCPA settlement negotiations. Additionally, regarding the other key aspect of the case, legitimate business expenses, lower courts will pay careful attention to disgorgement amounts to make sure that they are calculated to avoid being classified as a penalty, and that legitimate business expenses are deducted before ordering disgorgement. So the Liu case notes that to be deducted, the cost must be legitimate, and that the legitimate costs are those expenses that have independent value outside of the fraudulent scheme. And even in the Liu case, the court noted that the lease payments and the cancer treatment equipment arguably have value apart from Liu and Wang's fraudulent scheme. So for FCPA cases, parties should definitely determine early on what aspects of a bribery or other corrupt scheme were or would have been conducted by an individual or even a third-party agent, for example, in the regular course of business.
And so, Jessica, you mentioned how identifying victims is important, but in the FCPA context, that can be really tricky for a myriad of reasons. But there has been a recent district court decision that may change who qualifies as a victim in the FCPA context. I mean, if we just look at the Mandatory Victims' Rights Act, the term victim means a person directly and approximately harmed as a result of the commission of an offense, and that does include conspiracy. And a victim can be a corporation, a company, a partnership, or an individual. But as a victim, the company or individual could seek restitution for losses that it suffered as a result of that violation or offense. And there are a lot of difficulties in determining who can be a victim of an FCPA violation because it's not easy to prove a causal connection between the loss to the victim and the bribe or the corruption. And then, as we all know, FCPA enforcement actions don't always resolve in a conviction. I mean, many times, FCPA matters conclude with a deferred prosecution agreement, a non-prosecution agreement, where the defendant may not even admit to any wrongdoing. That said, lawyers for victims or plaintiffs had to be creative, especially because the FCPA does not give a private right of action. So the lawyers have used securities class actions, derivative actions, or books and records violation cases to recover a private claim for corporate bribery. So these suits may not lead to restitution per se, but they do compensate the plaintiffs for a loss due to the bribery and corruption. So one example happened in 2012 when City of Pontiac General Employees Retirement System filed a securities class action against Walmart, alleging that Walmart made materially false and misleading statements and failed to disclose adverse material facts concerning a bribery scheme that initially focused on corrupt conduct in Mexico. And then Walmart settled the suit in 2018 for $160 million. In 2019, the U.S. District Court for the Eastern District of New York, even though the DOJ objected to restitution, concluded that a group of OXIF subsidiaries, former investors, qualified as victims under the Mandatory Victims' Rights Act due to a bribery scheme. These former investors were equity holders in a company which held shares in a copper mine in the Democratic Republic of Congo that played a role in one of the bribery schemes that OXIF resolved with the SEC and DOJ. And these former shareholders alleged that they were damaged monetarily by the bribery. So initially, the DOJ claimed that any damages incurred by these shareholders were too speculative to merit a restitution award. But last July, just a few months ago, there was a proposed settlement, and it's now up to the judge to consider whether to approve it. So in the FCPA space, there have been examples of shareholders or investors being victims, but we've also seen in past plea agreements with regard to FCPA matters, foreign governments may also receive some type of restitution or compensation. For example, in the plea agreement for U.S. v. Diaz, the defendant was ordered to pay over $70,000 to the Haitian government, which was the fee for serving as an intermediary in a bribery scheme between government officials and a U.S. company. And then in a plea agreement in U.S. v. FG Mason Engineering, the agreement provided that a $160,000 payment plus discounts on future sales was required to compensate the German government for bribery of one of its military intelligence service officers. But please keep in mind, even though we have examples of foreign governments and shareholders and investors receiving restitution or some sort of compensation through creative means, it's important to keep in mind that competitors could also be victims of an FCPA violation or bribery scheme. So when determining whether there are victims and who they are, Lou points out that others may be joint and severally liable for that restitution or compensation to the victims.
That's right, Adria. The court addressed the SEC's practice of imposing liability for disgorgement on a joint and several liability basis against co-defendants. So while the court acknowledged that liability for partners engaged in concerted wrongdoing is permissible, the court also acknowledged that joint and several liability may not be consistent with equitable principles. So ultimately, although equitable relief generally requires defendants to be individually liable for their profits, the court also acknowledged that joint and several liability could be appropriate where defendants were partners in the wrongdoing. So this would allow plaintiffs to recover for the full amount of damages from any of the defendants, regardless of a defendant's individual portion of the fault. In the disgorgement context, this means co-defendants can be held liable, not just for the profits that they accrued for themselves, but also for the profits of others that, even if they weren't in close participation with those parties within a fraudulent scheme. The Liu court declined to adopt a bright line rule, recognizing that there may be a wide spectrum of relationships between participants and beneficiaries of unlawful schemes, which would make joint and several liability punitive instead of equitable. So the Supreme Court has now left it up to the lower courts to decide whether the SEC is authorized to impose joint and several liability on multiple defendants. This means that lower courts could determine that there are circumstances where individual liability is more appropriate than collective liability, depending on the spectrum of involvement among the defendants. The SEC may find this challenging. They might find it hard to establish that the misconduct of multiple defendants is sufficiently connected to justify multi-million-dollar disgorgement awards. based on more than just the conduct of one defendant. So going forward in these cases, the SEC will need to show this concerted effort piece. In settlement negotiations, defendants can attempt to limit disgorgement liability by showing the government that certain profits from an FCPA violation only benefited other defendants, like third-party agents. And keeping up with third-party due diligence, also being able to show a distinction in participation, will help limit liability for companies facing government investigation.
That's right. So if the defendant or a company has difficulty pointing the SEC to other companies or individuals who should be joint and severally liable, then the defendant should really focus on its legitimate business expenses, as we've mentioned before. And before Lou, there was not any differentiation between the disgorgement amount and any legitimate business expenses incurred by the defendant. And usually, like we've talked about before, the disgorgement award was based on the benefit obtained due to the corrupt payment, such as new sales. So given the Lou decision, let's look at a hypothetical concerning an FCPA violation that occurs involving a foreign government agency's purchases of a company's product or services. Like, what could those legitimate business expenses or costs be in order to reduce a disgorgement amount? So in this scenario, legitimate business expenses could include any bidding costs, the cost of manufacturing or creating product samples or the product itself, testing or certifications that are needed for the product to meet the foreign government specifications, marketing costs, such as travel expenses to show the product or services, or overhead that could be attributed to the bidding process and the sale.
So when negotiating with the SEC, companies should really consider three things. One, identifying legitimate business expenses. Two, identifying other defendants like third-party agents. And three, identifying legitimate victims. Companies really need to be able to identify on the front end costs, other defendants, and victims. The Lou decision highlights that disgorgement awards that exceed the net profits are prohibited. And the case highlights that if you prove legitimate business expenses are more than profit, then disgorgement is not necessary. So it really makes sense for companies to come up with anything they can show to show these legitimate business expenses. For instance, those facing disgorgement requests by the FCC should demand that all legitimate business expenses be deducted from any disgorgement amount. Companies should also press the SEC regarding its use for the disgorged funds. And if harmed investors cannot be readily identified, then companies should push back against the SEC's claim for disgorgement in those cases. Even if disgorgement is not on the table during negotiation, I would still bring up these points. Disgorgement doesn't have to be the opener. If there are others that could be jointly and severally liable, then I would mention this in negotiations too. And if all three of these things are present, then there's really no harm, no foul. The SEC or DOJ may push back, but this could be a good way to avoid the equitable relief piece.
Well, thank you, Jessica. I think it's important, too, to sort of take the time to raise a few current events related to disgorgement, but also FCPA enforcement. Just really quickly, yesterday, on September 23rd, the SEC approved amendments to its rules governing monetary awards made to whistleblowers who voluntarily report potential wrongdoing. And Jessica had mentioned earlier how some disgorgement proceeds have been used to pay those whistleblower awards. So since the enactment of the Dodd-Frank Act, the SEC has awarded about $523 million to 97 individuals since the whistleblower program began. And this new final rule creates a requirement now that individuals must contact the SEC in writing to qualify as a whistleblower. Another new aspect is that the SEC is now allowed to permanently bar any whistleblower applicants from seeking an award after filing 3 frivolous award applications in 1 year. There's also been 2 recent FCPA settlements that are worth noting. One involves Herbalife Nutrition from last month in August. Herbalife Nutrition is a US-based publicly traded global nutrition company. And last month it received, via a deferred prosecution agreement, it agreed to pay total penalties of more than $122 million to resolve the government's investigation into FCPA violations. And approximately $67 million was paid to the SEC in a related matter. The FCPA allegations included how Herbalife falsified books and records and provided corrupt payments and benefits to Chinese government officials for over 10 years for the purpose of obtaining, and increasing Herbalife's business in China. For example, Herbalife's China subsidiaries allegedly made payments and provided meals, gifts, and other benefits to Chinese officials in connection with obtaining sales licenses, stopping government investigations of Herbalife's Chinese subsidiary, and removing negative coverage of Herbalife's Chinese subsidiary in state-owned media. And in their books and records, the company characterized those alleged bribes, those meals and gifts and other benefits, as travel and entertainment expenses. There was also the announcement last month that World Acceptance Corporation agreed to resolve a $21.7 million FCPA enforcement action by the SEC based on the actions of a former wholly owned Mexican subsidiary that it had sold in July of 2018. World Acceptance Corporation is a consumer loan company headquartered in the United States, and the Mexican subsidiary allegedly paid around $4.1 million in bribes, either directly or through third-party agents, to both Mexican government and union officials over the course of 7 years. Among other things, the bribes were allegedly recorded as commission expenses. The SEC also noted that World Acceptance Corporation failed to provide FCPA training to not only its U.S. corporation, but also the Mexican subsidiary, and that there were a lack of entity-level controls over the Mexican company. So as part of the resolution, and without admitting or denying the SEC's allegations, World Acceptance Corporation agreed to pay $17.8 million in disgorgement. There's also a related DOJ settlement. Now, Jessica, we know that the DOJ and the SEC recently updated its FCPA resource guide.
Yep, that's right, Adria. The DOJ and SEC issued this update this past July, so we'll also include the link to this guide in the description box below. But the updated resource guide generally provides information for businesses and individuals about the FCPA and also gives some insight regarding how the government interprets the law in this area and its related enforcement efforts. The second edition provides many notable updates since the first edition was published in 2012, and I'll touch on some of those updates and areas to watch. First, compliance data analytics. The 2020 guidance places an emphasis on companies using data and testing as a way to show compliance. There is now an expectation that companies incorporate a process for conducting periodic risk assessment, and the DOJ will be evaluating whether companies regularly review and improve their compliance programs, including conducting periodic reviews of its risk assessments. And this is going to be based on continuous access to operational data and information across functions, not just based on one snapshot in time. So to do this, companies are expected to collect and review data to monitor, assess, and test their compliance programs. But while it's easy to say data analytics and monitoring are needed for anti-bribery and anti-corruption, this is not easy for companies to actually incorporate. And companies are now strategizing on how to meet the government's new expectations. For some, this sort of off-the-shelf product may be hard to use because these products really need to be tailored to the risk profile of each individual company. There is no one-size-fits-all product, especially when it comes to monitoring third parties. And in times like these, data monitoring can be expensive and may not be the priority for corporate budgets. But companies are also incentivized to show how they're using data to monitor risk and test policies and procedures, because recent settlements show us that the government is willing to provide leniency to companies who have implemented data analytics into their compliance programs. So first, understanding how these data analytics programs can be useful for overall management, not just compliance, may be a more cost-effective approach for companies going forward, sort of a hitting two birds with one stone approach. Second, there's a focus on middle management. The resource guide also highlights the criminal division evaluation of corporate compliance programs. This policy guides prosecutors in deciding whether a corporation's compliance program was effective at the time of the offense and also was effective at the time of a charging decision or resolution. Now there's a reference to middle management, not just upper management's role in setting the tone from the top for compliance. Middle management is in touch with the day-to-day business operations, and while they may take their cues from these corporate leaders, upper management is often too far up to make substantial and direct impacts on encouraging employees not to engage in misconduct. So middle management really has to be on board with compliance efforts, and a well-designed compliance program reinforces the value of middle management in avoiding FCPA violations. And third, the anti-piling on policy. So the SEC and DOJ regularly work with foreign law enforcement agencies to enforce international bribery laws and to coordinate corporate resolutions, even conducting anti-bribery trainings globally. Under the anti-piling on policy, the DOJ and SEC can coordinate responses with other authorities prosecuting the same company to avoid piling on duplicative penalties. This increased coordination with domestic and foreign authorities includes giving companies credit for penalties paid to other authorities. So, Adria, those are just some of the highlights that people will be able to look at in the updated resource guide. So it looks to be very helpful and clarifies a lot of areas, including the role of monitors in assessing effectiveness of compliance programs.
So now that we're at the end of our podcast, Jessica, I just want to say thank you to Davis Brooke Caswell, an Emory Law student, for her contribution to the podcast. Best of luck, Davis Brooke, in your last year in law school. We'll see you in the fall at the firm. And then, Jessica, I know you mentioned the description box. You can find there too, Jessica's in my bio. And please, in the comment section, if you can put any questions or topics you're interested in as a listener, we'd love to see it and love to consider it for future podcasts. Jessica, is there anything else that we should point out that will be in the description box?
Adria, I'll just also point out that we authored or co-authored publications back in April in the FCPA and compliance space. So we can also provide those in the description box as well. And we hope that you all will find those articles helpful. If you follow the links, you'll find first the JD Super article we wrote on the government's 2019 FCPA enforcement efforts. In the article, we talk about key takeaways and lessons learned from the 2019 highlights, like new milestones for the government, their further cooperation with international authorities, their continued use of independent corporate monitors. And we also provide practice reminders for 2020, like using global anti-corruption audits as an effective way to monitor third parties, like the ones we do for our clients, and using regular internal controls checks to also help minimize corruption risk. Second, you will find a COVID-19 compliance checklist. Adria and I wrote this checklist as a way to help guide our clients through the challenges that they now face as a result of the COVID-19 pandemic. The stressors impacting many companies right now are new and different, and this creates a sort of perfect storm for fraud and corruption risk. And we recognize that while companies are very busy changing their corporate strategies and priorities, legal and regulatory risks have not gone away. In fact, the risks are probably greater now more than ever. And we wanted to find a way to highlight and remind companies of steps they can take now to protect themselves and their employees from key compliance risks. So please take a look at these publications if you have a moment. And like Adria said, if there are other topics you would like for us to explore for you, we're happy to do that. And please let us know, what you're thinking. We appreciate you for joining us, and we look forward to the next time.
Absolutely. Thank you for joining us, and more content will come in the future.